Good evening, ladies and gentlemen. Welcome to Pro Se USA. I'm John Arigoni. This is William Foley. We hope you had a good holiday. And we got some news for you about what the Attorney General decided with the initiative petition. Now, as you know, we knew that he was going to come up with a form of denial because he had made that innuendo about the petition itself when we were at his office. So this is the letter that we have from the Attorney General, and it's regard to the initiative petition. Constitutional Reform Act Amendment for Election Reform. It says, Dear Mr. Arigoni and Mr. Foley, in accordance with the provisions of Article 48 of the amendments to the Massachusetts Constitution, I have reviewed an above referenced initiative petition, which was submitted to me on or before the first Wednesday of August this year. I regret that I'm unable to certify this petition as meeting the requirements of Article 48. One of those requirements is that no measurement proposed by initiative petition may relate to the appointment of judges. Article 48, the initiative, Part 2, Section 2, and it goes on to say, Section 4L of your petition contains an explicit restriction on the appointment of judges, and thus your petition is excluded from the initiative process. In a letter to my staff dated August 27, 2001, you asked that I strike this provision from your petition. There is, however, no provision under Article 48 authorizing the Attorney General to make any change in the text of a constitutional amendment proposed by an initiative petition. I must therefore decline your request to strike this language and must decline to certify this petition. I need not reach any conclusion at this time regarding other matters contained in the petition that may exclude it from the initiative process. First of all, we did not tell him to exclude it. We told him if he thought it was right, he could do it if he wanted to on his own.
And we would hold him accountable.
That's right, and that's why he didn't want to take it out. Now,
he couldn't take it out anyway.
Our Section 4L states this, and not one word says judge. It makes reference to officers of the court, officers of the judiciary.
Which are lawyers.
Pertaining to the lawyers, that's right. Now, the lawyers themselves are required to be officers of the court. And should they be elected to the legislature, then they are sitting in conflict. So the provision of 4L in our amendment with the initiative petition was to make it so they wouldn't be sitting in conflict, and to protect us from them making laws in conflict that they would utilize after their term to make money for their private commerce and trade. So, 4L reads like this. No officer or person under the control of the judiciary shall be sworn in as elected unless he or she relinquishes their license, post, or appointed office and severs all ties to the judiciary on the day they are elected, with full respect to the separation of powers doctrine established by the Constitution of the United States and the Constitution of the Commonwealth of Massachusetts. Where said person has been properly elected in accordance with the manner and procedures as outlined within this constitutional amendment, as a member of the executive or legislative branches of the Commonwealth of Massachusetts, they shall be barred from being an officer of the judiciary for a period of not less than 7 years after serving their elected term, including administrators, mayors, city and town council members of every city and town of the Commonwealth of Massachusetts. The purpose of this section is to reaffirm separation of powers, restrict the enactment of unnecessary law designed to promote litigation for the corrupt practice of barratry, and eliminate judicial conflict violating the separation of powers. It has no wording that says a judge's pay shall be decreased. It has no wording that says no one can be elected as a judge. In fact, anyone can be elected, or appointed rather, as a judge, but not someone from the legislature or the executive branch, because that is a violation of separation of powers. The provision here in this is simply the mandate of what the Constitution requires, which is separation of powers. It only performs the condition that the doctrine of separation of powers requires, that had not been mandated before. Now, the section that he refers to in the Constitution that says it shall not affect the appointment or pay of judges and so on is Section 2. And this is how the Section 2 reads of our Constitution. No measure that relates to religion, religious practices, or religious institutions, or the appointment, qualification, tenure, removal, recall, or compensation of judges. Now, that means we did not put anything in there that explicitly pertains to judges or the appointment of judges. The only thing we had in that article of L4 is that a member of the judiciary practicing law had to relinquish his ties to the judiciary in order to be in either of the other two branches of the government, being the executive or the legislature. He could not legally, according to our Constitution, be there anyway because he'd be sitting in conflict. Any one of them who wants to be appointed as a judge shouldn't be putting his name in to be elected as a legislature or an executive official. So he has a choice. The choice he makes holds him subject to the provision of 4L. So he has an educated choice. He knows the law, and he knows that if he wants to be an elected official, not of the judiciary, then he can't go back to the judiciary for 7 years. He does have a choice. And it doesn't stop anyone from being appointed to the post of judge, because he could still do that after 7 years, for one thing, and he could do it without having become a member of the legislature or the executive branch. So we did not put any restrictions on anyone not to being not to have the ability to be appointed as a judge, or to affect their pay or their term or anything else. All it does is enforce the separation of powers. Bill?
Well, he was concerned about a constitutional amendment that diminished and affected the salaries and the independence of the court, because we have to have an independent and impartial court. Therefore, they sit with life providing them good behavior, that they're not found corrupt, and they swear an oath to support the Constitution. Now, the Bar Association, which they are members of, violated the constitutional rights of every citizen to be considered a judge, because the right of equal employment and the right to be elected and the qualification of a sovereign person who is a citizen of the United States, was a king, and this Commonwealth, equal sovereignty, has the right to be a judge. Now, when they wrote the Declaration of Rights, prior to them establishing the Declaration of Rights, they tried to appoint their judges, the governors of the Commonwealth. And the people of Pittsfield said, oh no, and the Western Mass around here, over our dead body, you are not appointing your men as judges to rule over the law so that you can rule over us and control the law. We want equal right to be judges. Now, when they established the court, they also prohibited judges from making judgments that would affect a fair and impartial trial and judgment by one's peers. They made it a sacred right that judgments be by jury, and they barred judges from overthrowing judgments of juries. But we all know that the judges are overturning jury judgments. Now, in this particular case, we have a constitutional amendment that can be found on page 88 of the Constitution, official document from the Secretary of State, which refers to the amendment of Chapter 3, Article 1. And this says, the governor, with the consent of the council, may remove upon the address of both houses of the legislature, and provide also that the governor, with the consent of the council, may, after due notice, hearing, retire them from because of advanced age or mental or physical disability. Provided further that upon attaining the age of 70 years old, said judges shall be retired. Such retirement shall be subject to the provisions made by law as the pensions, allowance, or payment to such officers upon their voluntary retirement. This deals an article with the tenure that all commissioned officers shall by law have their officers and shall be expressed in their respective commissions as judicial officers. Duly appointed and commissioned and sworn shall hold their offices during good behavior, except such whom where there is a different provision made. And they make this, so they affected the judges' salaries and tenure. And under the Constitution, the legislature can't make a constitutional amendment that violates the tenure. So now, what he's accusing us of, he, the Bar Association, and he was in conflict because we were referring to him as lawyers, that the lawyers are sitting as officers of the court under direct control of the court, making laws for their profession. And we become a nation subject to unnecessary law, and we're being fined and we're being penalized under all kinds of pretexts. That's why you have crazy fines for not wearing your safety belt, not having this, not having that, and the double jeopardy of insurance companies benefiting by you violating the law, and then them justifying increasing your insurance. These are all rackets. This is a contrivance of a misuse of public trust for benefit of corporations to exploit people. Now the tyrant king did that, and we had a revolution. This legislature has betrayed us. Now, why have they betrayed? Because they're members of two political parties. So you know you can't vote for a political party in America. You can only vote for a person. But the same thing applies when we look at what the legislature did for political parties, to vote for political parties by group. And you could only vote for a political party under those provisions. And they fixed the machines so that you can't vote for anybody but a political party. So that's why people can't get elected. Now those are not fair and equal elections, because political parties, we have no authority to elect political parties. So we have this corruption. Now our petition dealt with correcting the unnecessary primary elections, because primary elections are basically an elimination process to eliminate people and to give political parties a monopoly and a control and give you the impression that it's legitimate to vote for a political party instead of a person. So this seditious, and that's what it was, seditious contrivance, bad behavior, is tantamount to corruption. And for such corruption, each and every one of them is indictable. Now we can't indict them because we don't have the Attorney General in our pocket. The Bar Association has the Attorney General in his pocket. Now the Attorney General is elected to office. And according to the Constitution, any person having the right to vote has equal elective franchise to be elected. Any person. And only a person you can vote for. They made a constitutional amendment that said in order to be elected Attorney General, you have to be an officer of the court practicing law in the Commonwealth of Massachusetts to be a district attorney or Attorney General. Well, under American jurisprudence, that issue, and American jurisprudence deals with the ethics of law. and Constitution. It clearly stated, where the Constitution establishes the public policy that says that the Attorney General and the District Attorney shall be elected, then the people have an equal right to be District Attorney and Attorney General. This qualification, invented by the Bar Association, was to control the law, to shield all the corruption, so they can commit crimes against humanity and crimes against us and not be indicted. Now, there's one provision in the Constitution that gives us the authority, the supremacy, and it hasn't been amended. And it's in the Declaration of Rights, and it's Article 5. And we can go to the Declaration of Rights in Article 5, and we can look it up, and we can read it to you. And there was no amendment to Article 5. Now, we have all of the articles in the Declaration of Rights, and all of the amendments to the Declaration of Rights to water them down. Now, there was a provision in the Constitution that says you can't amend the Declaration of Rights. That's like throwing out the Bill of Rights, the People's Bill of Rights. Like equal protection of the law, a little at a time. Article 5.
I'll read it for you, Bill. It says, all power residing originally in the people and being derived from them, the several magistrates and officers of government vested with authority, whether legislative, executive, or judicial, are their substitutes and agents and are at all times accountable to them. That means they're accountable to us. That means all of these things that Bill and I have been showing you, that our government officials and our appointed officials
are at all times accountable.
Right, that's what I said. Are always doing things to block us from holding them accountable. They know what they did, they know what we're doing, and they absolutely refuse to admit what they're doing, and they absolutely refuse to be caught at it. And that's going to trap them pretty good, because this is nowhere near over.
No, it isn't over till the fat lady stops singing. And I'm going to tell you something. If the fat lady stops singing, I'm going to get a sex change, and I'm going to start singing. Now, I'm going to tell you something, and I'm going to tell everybody else to start singing and not to stop. Now, we have to demand accountability. Now, under the principles of law, for any injury, you have a right to free access to the courts for wrongdoing, for recourse. They took away our recourse. They took away our right to jury trial. They violated the Constitution, a sacred right to jury trial, by infringing and abridging it with a rule by the court that violates the Constitution for the benefit of the association, the Bar Association, and the industry. Now, when we look at the Constitution and we look at the provisions in the Declaration of Rights, no man nor corporation or association of men have any other title to obtain advantages or particular or exclusive privileges distinct from those of the community than what arises from the consideration of services rendered to the public. And this title, being in nature neither hereditary or transmissible to children or descendants or relations by blood, the idea of a man born a magistrate or a lawgiver or judge is absurd and unnatural. Therefore, it's forbidden and forbidden. Yet they did this to you and me. They made themselves privileged by having a title granted to them by an educational institution. They gave them a degree in law, and by an association that established the curriculum to give them the degree, so they can go in the legal larceny business.